So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. I can't believe I'm late to the party, but we got to talk about this Equal Employment Opportunity Commission lawsuit that was filed in September, 2 weeks ago, alleging that Pensacola Furniture Store violated rights by forcing them to receive the jab. So the EEOC, the Equal Employment Opportunity Commission, filed a lawsuit on the behalf of Caitlin M. O'Neill. Caitlin M. O'Neill was working at Hank's Fine Furniture in Pensacola, Florida. In 2021, they put into place a mandatory jab policy. And their store manager and immediate supervisor told O'Neill that they would take her management position away if she refused to comply, no matter the reason, which I mean, that's a little bit insane, right? I mean, think about that. This person would still be, quote, unjabbed. They'd just be working there and not complying with this new policy, which is unbelievable. I mean, if you were concerned about the spread, you would fire her, I guess. But she had verbal and written requests, and ultimately they did verbal and written requests for religious accommodation. EEOC, who's filing the suit, says that they could have honored without undue hardship, which is really the base of this. There is no world in which there's an undue hardship suffered as a result of not doing it. There's an argument in the healthcare field, but I don't think that it's frankly a very good one, seeing as we know that spread can still happen, and in many cases it's enhanced by the job. And as a result, there's no world in which it poses an undue hardship to have an accommodation. The company ultimately denied all of her verbal and written requests and terminated her employment. So they're saying, the EEOC is saying that this is a violation of Title VII of the Civil Rights Act of 1964, which prohibits an employer from failing to accommodate an employee's sincerely held religious beliefs absent undue hardship. It's a no-brainer. They filed in Northern District Court of Florida. It's undoubtedly on its way to succeed. The EEOC is looking for monetary damages, including back pay, compensatory, and punitive damages, and injunctive relief to prevent such an unlawful conduct in the future. When researching this, I decided to go to the EEOC website to take a look at what they said in the past, because I was almost certain that the EEOC supported these mandates, which was, again, wild to me. Given the history of labor law in this country, specifically surrounding the EEOC, religious rights, as well as disability rights, there was no world in which this was acceptable under case law. And that's what I didn't understand in the time in 2021, how this could even be allowed, because it's very established that, there is no undue hardship posed by accommodating a religious exemption. There isn't any. And so you saw this from the EEOC, that they released the idea that it was promoted. But so I want to cover this here. They says that, well, federal EEO laws don't prevent an employer from requiring all employees to get the job, subject to the reasonable accommodation provisions of the Title VII. Well, ultimately, that means that it prevents an employer from requiring all employees, because there is no undue hardship which exists, which would prevent someone from doing this. And it's really clear. Again, the case law is quite clear. So you can see this is dated 7/12/2022. But at the top of the page, funny enough, of course, they write notice concerning the undue hardship standard. They said that, of course, in Supreme Court decision in Groff DeJoy, it said that the Groff opinion, quote, clarified that showing more than a de minimis cost does not suffice to establish undue hardship under Title VII, right? And I mean, this is hilarious. The Groff opinion didn't have to clarify it. That was established case law a long time. And the way we can illustrate this and talk about it is the actual results of Groff DeJoy. So as a reminder, in Groff DeJoy, it's a Supreme Court case. The person, Groff, was a mail carrier working as a rural carrier associate. He was an evangelical, observed Sunday Sabbath. Amazon contracted with USPS to deliver their packages, which ultimately meant that he had to work on Sundays. He informed the post office, Groff informed the post office of his need to accommodate his religious requirements by allowing him not to work on Sunday insofar as he covered the other shifts. USPS denied it. They did a memorandum of understanding in 2016, only allowing exemption of work for two reasons: if the employee had applied for leave on that day or if they had exceeded their limit of 40 hours for the work week. As a result, Groff continued to miss work on Sundays because he couldn't work, and ultimately resigned and sued USPS. It went in front of the Supreme Court just recently, and so I wanted to establish this here. There was a 3-page concurring opinion from Justice Sotomayor that wrote, for many years, EEOC had already been interpreting the undue hardship to be on the conduct of the company's business. Ultimately, the court ruled 9-0. So this is not, a rogue Supreme Court justice, or it's not a 5-4 decision with the conservatives winning. All 9 justices voted in favor because it was already an established practice under the EEOC. It was already what they were doing. And so for the EEOC to come back and say that their change of mind was as a result of Groff v. DeJoy is not accurate. That has been the EEOC's interpretation of the undue hardship for for a long time. And so the idea that their previously established case law, promoted mandatory jabs is not true. And it was, again, driving many HR professionals a little bit crazy because we knew the history there and we knew that that was not an expectation under the EEOC. However, employers still continued to terminate, and they will reap what they sow, I think, because this court case will unleash an avalanche of more court cases in which those companies will absolutely lose. And it's not because of an activist EEOC or an EEOC that, is under the sway of politics. This has been a longstanding practice in the EEOC for a long time. And the idea that businesses will suffer as a result, I don't feel bad for them. Anyone with any understanding of labor law wouldn't know that they were going to suffer all along. Let me know what you think in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.